Bismillah. Let's all settle, inshallah, so we can get started. What's your name again, Professor?
I'm Professor Downs.
And
Downs.
I'm Professor
Young, Professor Young Downs Jr. Okay. Bismillah ar-Rahman ar-Rahim. Alhamdulillah wa salatu wa salam ala Rasulillah wa ala alihi wa sahbihi wa man wala. Alhamdulillah, we have a nice program, inshallah, to educate us about arbitration. I talked to our friends here about the topic, and I can declare that I was 100% ignorant about it. I didn't know what is actually consumer arbitration. I know arbitration when people have disputes, but consumer arbitration is a very interesting topic. And Omar is a young Muslim, mashallah, we're all proud of. He's a law student, and we have some of his professors, and we have Judge Gina here too. So inshallah, we will learn and benefit from them, inshallah. We all need that benefit, inshallah. So we will start the introduction with Professor Downs, one of Omar's law professors. Please.
Thank you.
And my name is Ashton.
Oh my goodness. And good afternoon. Thank you so much for having us. My name is Professor Angela Downs. I'm a law professor at UNT Dallas College of Law. I have brought my co-counsel here with me. But I'm so thrilled to be here with you to talk about this very, very important subject of consumer law and consumer arbitration. You would think that consumer arbitration only affects big businesses, but it does not. You as a consumer touch arbitration in all of your interactions. Every contract that you sign, even when you rent a car, when you go out and get a credit card, you're being touched by arbitration. And what we found is that in the pandemic, folks are relying on credit cards more. We've seen an increase in unemployment, and we've seen a lot of folks who have reached out for payday loans and other mechanisms so that they have income. So we want to talk to you today about the pitfalls. We want to give you some solutions, and I am thrilled because we have some experts here who are going to be talking to you and providing some wonderful insight. So I'm going to go ahead and introduce our panel at this time. Just a moment. On the far left is Judge Gina Slaughter. Judge Slaughter is a judge of the 191st in Dallas County, where she has been on the bench for 15 years. She is a consummate professional, and she has always receives one of the highest ratings for judges in Dallas County. So we are thrilled that Judge Slaughter has devoted a little bit of her afternoon to be with us today. Excuse me. Seated next to Judge Slaughter is Rick Faulkner. Rick Faulkner is considered one of the experts in international arbitration. He's arbitrated cases in the U.S. and abroad. He has some of the highest credentials in arbitration and is a known expert in arbitration. So he's here to lend his expertise. Seated next to me is my daughter, my co-counsel. She is a first grader at the Green Hill School, and she is thrilled to be here with you. To my right is Omar Itani. Omar is a law student at UNT Dallas College of Law. He's also a community engagement ambassador. And what that means is that Omar works with a team of law students to bring information and programming to different communities in Dallas. Omar and his team have been looking for different communities to bring this program. They have researched this topic, and we consider them law school experts on consumer arbitration. Omar is a very outstanding student. I've had the pleasure of having him in my class. He's very smart, and I really see some really bright things in his future. So with that, I am going to turn it over. Oh, I also need to talk about a little bit about the school. Hold on, just a minute. So let me talk a little bit about UNT Dallas College of Law before I pass the mic over. We are, at UNT Dallas College of Law, we are very committed to issues of social justice. And one of the things that we are looking to do with our law students is to ensure that no matter what type of law that they practice, that they are exposed to different issues that affect those that we hope to serve. This issue of having a social impact is baked into our mission statement at the law school. And because of this, we have a location for our law school that's in downtown Dallas. This affords us the opportunity to be close to the court system, the criminal courts, the civil courts, as well as the federal court and the municipal court. We're located in the old City Hall building. It's a beautiful space, and hopefully when things open up after the pandemic subsides, we'll be able to open our doors and to welcome visitors. But we also have programs in legal clinics. Our legal clinics are called community lawyering centers. That's by design. We want to provide neighborhood-based legal services to those who need legal assistance. And they are located in the community, so they are not located in our law school. They are, in fact, we have two locations. One is 4 blocks from our law school in the City Square building. The City Square building is a multi-economic building that houses folks transitioning out of homelessness, middle-class residents, as well as condos on the top of the building. Our next location is located in the Fraser Neighborhood, and that is south of Fair Park. And we love being there. We've been embraced by the community, but we found that for folks who need legal assistance, it's important to become part of the community. So that's something that is very important to us at UNT Dallas College of Law. And we're so thrilled to be here with you today, hoping to expand our reach and actually hoping to see if we can plant some seeds to perhaps do some pop-up clinics here with you at some time in the future. So at this time, I will pass it over to Omar. All right.
Assalamu alaikum, everyone. Can y'all hear me okay? Should I? No mask? 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 Okay. So the reason we wanted to have this presentation is because COVID-19 has affected everyone, and people who were financially struggling before the pandemic are struggling even more now. And issues with arbitration are not generally well known, but they can have a huge impact on your financial health and well-being. And in order to protect yourself from the dangers of arbitration agreements, we wanted to have this program to help other people basically get a better idea of it. But let's go back for a second. What is arbitration? So arbitration is essentially another way to resolve a dispute, similar to going to court. It's a private process where you're resolving conflicts, and at the end of the day, the arbitrator will decide and it's done. So it's just a very quick way to solve disputes. So it's not similar to mediation. Mediation is just being able to possibly negotiate a settlement, but arbitration is just a way to end it, just like with going to court. So a few key terms to consider. An arbitrator is essentially the judge. That's their kind of parallel. And an arbitration award is like the judgment that the judge issues. Now, where some differences come in are arbitration clauses, which are parts of contracts that actually compel arbitration. So what this means is that companies will have contracts, and inside they'll say that by agreeing to this contract or by signing, you are agreeing to settle future disputes through arbitration. What this means is that instead of being able to go to court whenever you have a dispute, you are giving up that right, and you're going to have to go to arbitration instead of being able to go to court. So this is just a sample arbitration agreement from American Express. Companies have a lot of things similar to this. You don't really need to see all the text, but here are just some general parts. A lot of times these contracts will let you know that you are going to be bound by arbitration, which is the arbitration designation, and it'll explain the effect of the arbitration, and it'll also sometimes explain various costs that go with it, or the effect that the arbitration will have on you, who the arbitrator may be, or where the arbitration may take place. So this is just a sample to keep in your back pocket. So like I was saying, it's similar to court, but the main difference is that it's a lot more informal. So when you're going into arbitration, you're not having those protections that you have when you're in court. There's no federal rules of evidence to protect you. There's no rules of civil procedure. It's very much just a quick way to come to the end of the dispute. So you're really not having the same procedural protections that you would if you were going to court, which is good for companies because they're trying to get your stuff settled quickly and they're trying to win. They're not trying to pay out to you if they've injured you or if they've tried to take advantage of you in a contract. So generally the cases are presented just like in court. You have both sides will argue their case and they'll present evidence, and at the end of the day the arbitrator will issue a decision, and that decision most of the time will be binding, which means that it's final, that's it. So this is just an example of some of the companies that have arbitration agreements. As you can see, there's a lot, and this is just very, very a small sample size. Most companies have some kind of arbitration agreement. And as you can see, it's not just relegated to one industry. It's not simply tech companies that have it or something like that. You're being stuck with arbitration agreements whether you're buying a mattress or a camera or getting baby food. There's so many different things where arbitration agreements come into play. And you find them most of the time whenever you're signing contracts for things, but also whenever you're scrolling through something online, you know that box that says, I've agreed to the terms and conditions, and you just check it without actually reading what it is, because who reads the terms and conditions, right? Well, a lot of times arbitration clauses are put into those terms and conditions, and by clicking that box, you're subjecting yourself to arbitration without even knowing it. So this applies in gym membership contracts, getting a job, getting a massage even, just pretty much anywhere. Like most people don't even realize that this is so pervasive. But if you have signed those, then you are subjected to the arbitration agreement, which means if something happens in the future and you want to sue that company for any reason, you're not going to be able to. You're going to have to go through arbitration. So there are sometimes ways out of arbitration. This is an example from Massage Envy's arbitration clause. And this is basically smack in the middle of the contract or the terms and conditions when you read it. So unless you actually find this needle in the haystack, you're not really, there's nothing that makes it stand out of the page besides being in bold. So for the most part, people aren't actually seeing these. And if you actually look at what it says, signing the agreement is going to automatically subject you to arbitration, and the only way to not have it be binding is by following all the steps up there. So you have to submit a written agreement within 30 days. You have to jump through all their hoops in order to try and avoid losing your rights to settle your case. So essentially, arbitration is, instead of having a fair trial being guaranteed to you in court, it's just a quick way out for the company, and you are not being able to have everything settled with the full protection of the law that's required. So I just want to give an example of a couple who were taken advantage of by JD Byrider. They were buying a car, I think two maybe, and they had expensive warranties tucked into the contract, and they had no idea. So they were being manipulated and taken advantage of by the company. They were out a bunch of money, so they sued because they thought they were victims of fraud, and they were. But what ended up happening was the court looked at it and said, well, hey, look, you signed an arbitration agreement, so you have to go to arbitration. You can't go to court. And these arbitrators are being picked by the companies themselves who are mandating arbitration. So 94% of the time, I think was the statistic, people who are representing themselves in arbitration are going to lose. So you're setting yourself up for a 94% chance of failing in arbitration. Another issue with arbitration is diversity. So Jay-Z was actually forced to go to arbitration a few years ago for an alleged contract breach, and he actually was able to kind of buck the trend a little bit. He got the arbitration paused for later because there were actually no available African-American arbitrators. There were just none. It's a very, very much a monolithic type of industry, and a lot of people's interests aren't adequately represented in arbitration as well. So there are quite a few different issues that you're being sucked into just by clicking the terms and conditions and not even realizing it. One last thing I want to mention is payday loans. They, 99% of the time, will have an arbitration clause tucked in there. And for people who are struggling, it seems like an easy way to make ends meet now, but with super, super high interest rates, if you miss one payment, you're kind of already in the hole, and it's going to be really bad for you. And instead of being able to bring a dispute in court against the company because of this being taken advantage of by these payday lenders, you're going to be stuck going to arbitration, and you're not going to be able to have your dispute heard. So. Now to talk about protecting yourself from predatory arbitration agreements, I'd like to bring up Mr. Faulkner. Oh, yes. Thanks.
Well, as I shared, and before we go any further in our program, I really want to take this opportunity to thank the leadership here for having us. This means so much to us at the law school to have this opportunity to come with you here today. And I take this time to introduce you to Judge Gina Slaughter. As I shared, she is the presiding judge of the 195th District Court, where she presides over civil cases. She's held that position for 15 years. She is considered one of the finest judges in Dallas County, fair, impartial, but also open to listening to consumers and things that they have to say before her in court. So without further ado, Judge Gina Slaughter.
Thank you.
There you go. Okay. I'm going to stand over here. I hate standing behind podiums. Hello. So I'm Judge Gina Slaughter, and I'm the judge of the 191st District Court, and thank you for allowing me to be here today. So I've been a licensed attorney for 20-something years, and I did mostly business litigation, mostly construction related. And there are arbitration clauses in most construction contracts. Okay, there were arbitration clauses in really sophisticated, complicated business deals over a lot of money. And I saw Jamal nodding at construction. Anybody who has ever seen any kind of construction contract, there will be an arbitration clause. And that was fine because those are more sophisticated parties. Those are really negotiated contracts. You had a way of working around it, knowing what you were doing. Arbitration is now everywhere. I jokingly laugh because I was at home the other day and I needed some new suits because now that the pandemic is winding down, hopefully, and I'm going back to in-person court and I need more clothes. When you go to the Dillard's website online from your own home, a little screen pops up that says, by continuing to shop on this website, you're agreeing to our arbitration clause. I'm buying a jacket, right? I mean, mean, this is insane. And most people, I know what that means. I know what the problems with arbitration are. I know how to use the system. Most people don't. And that is one of my big concerns as a judge. So in court, we have two kind of areas of things I deal with. The first is substantive law. What does the law say? What do statutes say? What does case law say? What is the substance? And how do the facts of each case apply to that substance? And then we have procedural issues, which are the rules. How do we get from A to Z, and what rules have to be followed? Perfect example of that is service of process. So you file a lawsuit in court, and you go to the clerk, after you file it, you go to the clerk and you ask for what's called a citation to be issued, which literally says, to Jamal, you have been sued. You need to file an answer. You know, bad things will happen if you don't. And it's got the lawsuit attached to it. Arbitration, they can mail it to you. Regular mail, not even certified first class. Nobody has to serve you. Nobody has to, you know, the constable doesn't have to come find you. They just mail you something that said, we've demanded arbitration. Most people don't know what that means. They don't, again, know the result of that. So in court, if I do something wrong, you're in my court and you disagree with a ruling I make, there's what I call a court of appeals above me. And we jokingly say they grade my papers, right? They literally look at what I've done, the transcripts, the pleadings, the facts of the case, the law of the case, and say either, okay, you did okay, or no. And they look at both the substantive law, right, the facts. Did I understand the facts properly? Did I make the right conclusions from those facts? And the law, did I apply those facts to the correct law? Did I apply it, you know, was it done correctly? And they look at the procedure. Did I allow evidence in that shouldn't have been allowed in? Did I not require a certain way of service or something? They look at all of it. If you go to arbitration, the only way I can do anything about an arbitration award once it has been issued is the procedural rules. Okay? I have to look at the rules of the procedure for whatever, you know, rules you're operating under for arbitration and say, did they follow those rules? They can be wrong. Arbitrators can be wrong on the facts. They can be wrong on the law. They can be wrong on pretty much everything. But as long as they followed the right process, I as a judge can't do anything about it. And that's, I gotta tell you, incredibly frustrating as a judge. But it's the truth. So it's very important that if you get served with a demand for arbitration, that you don't just not understand what it means and ignore it and not do anything. It's very important you participate in the process. And as they pointed out, as Omar pointed out, arbitration clauses are everywhere now. Like I said, Dillard's. I'm going to sue them over a $150 suit jacket. Oh, wait, no, you have to go to arbitration. That doesn't make a lot of sense. And I'll warn you right now that a lot of these companies that have arbitration clauses do what I would politely call hedging their bets, which is if, let's say, Avis Rent-A-Car wants to sue you, okay? You borrowed a car and wrecked it and don't want to pay. They're going to file that suit in court, knowing they have an arbitration clause. Okay, that seems counterintuitive, right? Well, it isn't, because they know that a high percentage of people aren't going to do anything about even being sued, okay? They won't file an answer, they won't hire an attorney, they won't do anything. And it's cheaper to actually litigate in court than it is to arbitrate, because in arbitration they have to pay a filing fee. And the filing fee is linked directly to the amount in controversy, right? In my court,